Hello everyone. Today we are going to discuss a Supreme Court decision which deals with the rights of persons with disabilities. In this particular case, we see that the petitioners are persons which are facing or have facial disfigurement or severe eye burns. They are acid attack victims. The second petitioner in the case is suffering from 100% blindness. The respondents are regulatory authorities and statutory bodies which use digital platforms for carrying out certain processes, and these processes are something which persons with disabilities are facing difficulty with. Now, the process that we are talking about is digital KYC or eKYC. eKYC or digital KYC comes from the term know your customer. The primary aim being to identify the customer, to record the identity of the individual. Now, this includes the aspect of taking a live photograph. A live photograph basically thus involves the person's face to be in a certain angle. There may be the aspect of eye blinking, which has been mentioned here, that is required. Now, bearing in mind the disabilities that we just talked about with the petitioners, it is difficult for them to fulfill these processes. And since KYC or eKYC has become indispensable today, it becomes difficult for such individuals to even have basic things like opening a bank account, a SIM card, demat accounts, etc., have become struggles for them, right? And therefore, we realize that the indispensability of eKYC and digital KYC is something which creates a sort of hindrance for persons with disability because it's not very accessible to them. Additionally, the requirements of the Prevention of Money Laundering Act and the Prevention of Money Laundering rules comes with the idea of a scrutiny of the customer or of such persons who are engaging in digital platforms. So, therefore, the concepts in PMLA and the prevention of money laundering rules like authentication and due diligence and the requirement for reporting entities to verify the identity of their clients, reporting entities being banking companies and financial institutions, this aspect of KYC becomes further important, and the inability of a persons with disabilities to fulfill that also is maximized, and therefore creating a difficulty for them to access basic things like trading accounts and so on. Now, coming to the fact that sections 42 and 46 of the Rights of Persons with Disability Act already mentions that there is a requirement for access to information and communication technology to persons with disability. Additionally, there is a timeline given for its compliance by both government or private sectors. So, there is already a requirement that you must provide access to information and communication technology to persons with disability, and a timeline was already provided for. However, we see that this kind of difficulty is being faced by persons with disability. The Supreme Court now referred to multiple cases emphasizing that they have acknowledged and reiterated the importance of accessibility and inclusivity. In the Rajiv Raturi case, which the Supreme Court has referred to, the accessibility as a fundamental right has been recognized under the umbrella of Article 21. Secondly, the recruitment of visually impaired in judicial services case also reiterated the importance of the RPWD Act and how any violation of the same would be a violation of fundamental rights. Additionally, the distribution of essential supplies and services during pandemic case was also referred to by the Supreme Court, and it mentioned that digital platforms relating to vaccination must be accessible to all, and it should be in a way that persons with disability must be able to access the same. Thus, the Supreme Court has referred to its own decisions on multiple occasions within this case, right? And now, coming to what did the court actually hold? Now we see acknowledgement from the court. The court says that in this particular situation, there is a difficulty faced by persons with disabilities. It says that there is a requirement of blinking, and there is a requirement of certain specific movements in such processes which may be difficult for persons with visual impairment or with disabilities, especially those of nature of the face or of eye disfigurement, right? And it subsequently now makes a statement that if we read Article 21 with Article 14, 15, and 38, it leads to the conclusion that the state has a responsibility to ensure sufficient digital infrastructure so that persons with disability find it accessible to fulfill such procedures. This decision provides multiple solutions to the same also, and it lastly, most importantly, makes a mention that the right to digital access comes within the umbrella of right to life and liberty, and stating that it is necessary that the state proactively designs and implements inclusive digital ecosystems that serve not only the privileged but also marginalized, those who have been historically excluded. So the court makes a big statement of stating that digital access is a part of Article 21 and issues 20 directions in relation to the same. Some of the important directions of them are the appointment of nodal officers who will be present in every department responsible for digital accessibility compliance. It also mentions that an accessibility audit will be conducted, and also that grievance redressal bodies or agencies can be established in order to deal with difficulties or complaints in accessibility, apart from the different other guidelines which have been provided by the court here, the directives that have been provided by the court here. So I hope I was able to give you an outline of this particular case. Persons with disability, especially of facial and visual nature, find it difficult to fulfill the digital KYC procedure because of its blinking aspect or the aspect that the face has to be in certain angles. There are also certain other options and requirements of the KYC process which the case deals with and which has been found difficult by persons with disability. The Supreme Court recognized that, said that right to digital access is a part of our fundamental rights through Article 21, and therefore these regulatory bodies have to take efforts, have to comply with the Rights with Persons with Disability Act and ensure that digital access is available to them on these online platforms and portals. I hope you enjoyed the video. Please like it in case you do like, and comment. Thank you everyone. Have a nice day.